Thank you very much, Mr. Chair, for the call. Sorry, what was that? No call being taken by Sam Lotu-Iiga on this bill. In fact, no calls whatsoever on this bill from National Party members other than a brief intervention from the Minister last night. Because two reasons: they don't understand it, that's the first reason, and secondly, they're not proud of it. They're not proud of it over there because they know this takes out the balance between protecting the security of New Zealanders and protecting the rights and freedoms of New Zealanders. Sam Lotu-Iiga wouldn't have a clue what's in this bill. He's blindly going along with it. He's been told he's got to stand there. He'll try and move a closure motion at some point. That's the best he's got to contribute. Well, I challenge Mr. Lotu-Iiga to stand up, get on his feet and say that... The point of order?
Point of order. Sam Lotu-Iiga.
Thank you, Mr. Chairman. He asked me to stand up and get on my feet. I'm up. Point of order. My name is Sam Lotu-Iiga. Thank you.
Yeah, well, I ask members to pronounce other members' names correctly.
I stand corrected. I'd still like to see the member take a call in this debate. He's off. He's off because he doesn't know anything about it, Mr. Chair. He doesn't know a thing about it. Mr. Chair, he's going to find those houses in Mangakeke that he was looking for, the affordable ones. They're not there. Mr. Chair, several issues to come to now in Part 4 of this bill. And the first one I want to do is pick up on one of the points that Claire Curran raised, which is around the question of the role of the special advocate and whether or not a court can hear matters in the absence of the defendant. In this is covered under essentially clauses 95 onwards in the bill. And I want to make reference to what was a very significant report written by the Human Rights Commission. And the Human Rights Commission is allowed, under its direct reporting function, section 52K of the Human Rights Act, to deliver a report to the Prime Minister. It has only delivered, as far as I'm aware, in its history, 5 of these reports. So it's a significant step, and they chose to deliver a report to the Prime Minister on this bill and on the GCSB bill. And that was a significant step. Those who've been following the saga of these bills will recall that was what inspired the Prime Minister to threaten the funding of the Human Rights Commission and to suggest that they should get their submissions in on time. He actually didn't understand that this was a separate process and a very serious one. And here's what they had to say about this exact power. Of further concern is the fact that where procedural matters involving classified security information relating to administration or enforcement of the Act are involved, at the request of the Attorney-General, a court can receive or hear matters in the absence of the defendant or the defendant's lawyers. Now, they note that there is the provision for special advocates, but they believe, the Human Rights Commission believe, that this breaches the right to natural justice under section 27(1) of the Bill of Rights Act. So this bill, and as my colleague Claire Curran said, got a cursory look from the Attorney-General and a rubber stamp through here. Here's the Human Rights Commission saying this part of Part 4 breaches the Bill of Rights Act. And along with many other issues, this is exactly why Claire Curran moved a motion before the second reading to get this bill back to the Select Committee. There's a massive supplementary order paper here from the Minister, some significant changes, a lot of issues left unchanged, and we know from the submissions of agencies like the Human Rights Commission, significant concerns not properly dealt with. Interestingly, they go on and they say in their submission to the Prime Minister, despite the opinion of the Attorney-General to the contrary, the Commission considers the limitation is unjustified and a disproportionate response to the need to protect classified security information in this context, particularly since it is relatively unclear as to who will be appointed as a special advocate or if one will be appointed at all. So that's the situation we now have, and I'm not a lawyer. My colleague Andrew Little is a lawyer, and I'm sure he'll take a call as we go on through this. But a basic principle of natural justice is that if you're going to be talked about in a court, you have the right to be there and be represented. It's a fairly fundamental and basic right, and the Human Rights Commission is saying Part 4 of this bill undermines that. That is an extremely serious allegation, and we've heard nothing from the government to defend that. They've given it the rubber stamp, and they seem to think that's fine. Well, sir, on this side of the House, we do not think that is fine. We believe that that needs to be thoroughly analysed, and at the very least, Mr Chair,
Grant Robertson,
and at the very least defended by the National Government as to why they are prepared to trample on the principles of natural justice in such a way that it has led the Human Rights Commission to put this in. Now, the government may well say, because there's no government members prepared to defend this, so let's put up the argument that they might put up. That would be that the special advocate is there to deal with this. Well, the appointment, and this is consistent throughout this bill, the appointment of the special advocate right there in the hands of the government. And when it comes to these matters of security and intelligence, we on this side of the House simply do not have the confidence that the government will appoint the appropriate people. We've seen consistently over the term of this government the appointment of cronies, and then obviously the major one of those is the appointment of Ian Fletcher to be the director of the GCSB. That has undermined the confidence of New Zealanders in these agencies, and now we have to accept that anyone who ends up in this process has to go along with the special advocate. We don't even know if the special advocate is going to be appointed, but they have to go along with the special advocate as their person. That fundamentally raises questions of natural justice. That's why the Human Rights Commission raised this, and I would ask a government member to stand up and answer the Human Rights Commission's concerns. No government member in this debate has properly responded to the concerns that have been raised. The Minister and the Chair could stand up and tell us why it is that his government is prepared to go against the Human Rights Commission, who have put out one of the very few direct reports that they do to the Prime Minister on this bill and on this particular part of this bill. And national members should be able to defend that, otherwise it shouldn't proceed. Because what is the point of having an agency like the Human Rights Commission if they're simply going to be ignored time after time and undermined by this government? But we have not seen any adequate response, and on this side of the House, Mr Chair, we believe that this part and this bill should be opposed in part because of that. Another of the matters that I want to raise in Part 4 is around clauses 70 and 71, which are around the idea that there needs to be a government-sponsored security clearance for network operators who have 4,000 or more customers. And I thought this was a good example, Mr Chair, of the point that Claire Curran raised about some of the costs and obligations that are being put on companies under this Act. Many of us in the House will have experienced the process of going through a security clearance, or indeed being a referee for somebody who's gone through a security clearance. I have to say, it's not always the most reassuring of experiences when that occurs. A person in a long raincoat. Well, actually, Mr Goff says I got through. Perhaps members of the House may want to consider that that is not that reassuring. But members, somebody from the SIS comes in a long coat. Yeah, Trevor Mallard failed, so the system does work in the odd occasion. But the point.
When I worked in the Defence Department as a window cleaner, I had a pistol picking guard.
And we've always wanted to keep Mr Mallard under armed guard since then. But the point I'm trying to make here is another obligation and another role for a security agency. We on this side of the House have been waiting expectantly for the Security Intelligence Service to be reviewed. It was something that the government began and then stopped for no apparent reason and without explanation. But here the SIS is involved, along with the GCSB, in having a role in deciding how network operators are going to behave, what obligations are upon them. The vetting process is the issue that I want to raise, Mr Chair. I understand actually that as part of the process of this bill, part of the vetting process that the SIS does may have actually been revealed as part of this bill, and that in itself is of concern, Mr Chair, because I would have thought that was something the SIS may well have wanted to have kept to itself. So there will be more to say about that in the future, but this is just another example in Part 4 of additional costs and additional obligations that are being placed on businesses and network operators. And if we look at Part 4, which is essentially a set of clauses that... No, I've been there the whole time, Mr McKelvey. I've been there the whole time because the human rights issues that I raise that Mr McKelvey hasn't taken a call on, he could get up and respond. Everything I've been talking about, Mr McKelvey, is in Part 4 of this bill. If you read the bill, get up and take a call and tell me how you, as a member, how Mr McKelvey, as a member, justifies breaching the Human Rights Act. That's in Part 4, and not one of those government members will defend it.
Mr Chairman,
The Honourable Phil Goff.
Mr Chairman, it is a worry that when you have a bill like this and an important part of the bill